Mr. Ogbeide Ifaluyi Isibo, who is a member of the PDP, an official spokesperson of the Asue Ighodalo team. He's also a former commissioner for digital economy, science and technology in Edo State. Thank you so much for coming on the programs this morning.
Thank you very much for having me. It's a pleasure to be here.
I see you're still able to manage a smile, and this is very commendable. The question is, how did you receive the judgment yesterday? I mean, you heard some of the things that our correspondent, captured in that report. She talked about why the tribunal rejected the petition of the PDP, who were the main petitioners. Yes, there were other petitioners, that of the AA and Accord Party as well, but it looks like all of that was thrown aside. But for the Asue Ighodalo team, who were the main petitioners, they spoke to the fact that they couldn't scrutinize documents. They spoke to the fact that they could not be scrutinizing the BVAS machines, which were dormant. They wanted, more evidence in proving overvoting. And they also spoke about hearsay, that the witnesses that were brought were speaking from hearsay. They did not witness things firsthand. What were your thoughts on that?
Well, thank you. Thank you again for having me. We had absolute confidence in the documents we tendered in courts. We had absolute confidence in our legal team because we had put forth the wishes, as documented in INEC materials that happened at the September 21st, 2024 governorship election, where the Edo people came out to express themselves and they gave their votes overwhelmingly to Asue Ighodalo. But suddenly, INEC declared someone else the winner. That was why we went to court. And we were miffed beyond words when we started to hear the pronouncements of the judge, which was, in our opinion, contrary to the Electoral Act. I mean, if we were complaining about overvoting in 133 units and documentary evidence from EC8As from the polling units could show that the number of votes cast exceeded the number of accredited voters, the Electoral Act in Section 51, Sub 2 easily says that is overvoting. You did not need a witness to prove overvoting, according to the Supreme Court judgment in Ighodalo versus Hope Uzodimma, where APC presented just 2 witnesses. And the Supreme Court said, in line with Section 137, where there is an issue of non-compliance, for example, and the appellant is able to prove by documentary evidence that INEC did not submit herself to her own guidelines, that all evidence was not necessary. You see, we pleaded about 3 cases. 1 was non-compliance, 2 was overvoting, and 3 was incorrect collation of scores. And so I will take them one after the other. In the case of overvoting, like I just said in Section 51 Sub 2 of the Electoral Act, that easily explains what overvoting means. We tendered documents, INEC certified true copies. These were INEC documents to prove overvoting. And we were shocked that the judges wanted us to bring 133 individuals from each polling unit to prove overvoting. How was that expected to happen when there was documentary evidence, not PDP documents, but INEC documents? And the courts had accepted those documents as exhibits, and INEC did not, cry foul to her own documents. So we were, in the street betwixt two as to what does the court really expect us to prove now. But if we've shown you INEC documents where those who voted in several polling units were beyond those who were accredited to vote. We showed you that in the forms EC8As from INEC. We showed you that in the BVAS extract, also gotten from INEC, certified true copies. How else was the court expecting us to prove overvoting? That was 1. Section 72, Sub 1 of the Electoral Act easily expresses that INEC is supposed to do a prior recording of the serial numbers and quantities of sensitive election materials, ballot papers, BVAS machines. And where that is not done, the election in those polling units have to be invalidated. And so we brought evidence before the courts that in over 300 polling units, there was non-prior recording of sensitive election materials.
In other words, non-compliance.
Absolutely. And if the law says that the elections in those polling units should be invalidated, do justice to the case. And that's what we prayed the courts to do. And so we were also shocked to hear the judges tell us that we did not bring witnesses to speak to those. Witnesses were not supposed to be there when there was prior recording, because that was an exceptionally INEC duty. It was for INEC to prove to the courts that they actually did the prior recording, which they didn't do. INEC brought no witnesses. The PDP did. So how was it that the court was expecting witnesses who were not INEC officers to prove non-compliance when the documents obviously could show that there was non-compliance? Then the issue of incorrect collation of scores. There were several polling units where INEC, maybe by the fault of theirs, I don't understand, dashed the APC thousands of votes. And we were saying, look at your originals. Look at the Beavers machines. Look at those who voted, because the Beavers machines captures the number of people who came to vote, and the photographs of these people who voted, they're time-stamped. So if the official results in the Form EC8A says 52 people came to vote in polling unit A in this ward, and there are 52 photographs of human beings who came to vote, and how come we're seeing results sheets of 1,000 people and 800 voting for the APC and maybe a couple voting for the PDP? So we brought all this evidence before the courts in line with previous rulings at the appeal and the Supreme Court, and to tender these documents to say INEC, to the courts to say, look at what evidence we have, look at what INEC did, do the math yourself, and declare who had the highest number of lawful votes. And while I saw the video just now of APC members celebrating, as expected, the Edo people are mourning. There is nowhere in Edo State, from yesterday till this morning, where there's a group of people celebrating this Jordan, because Edo people gave their votes to Asue Ighodalo. We know he won the elections. And people all over the world were looking up to the tribunal to determine. So the Edo case was going to be, what was going to be the last straw for the people. Do we still have any confidence in the judiciary? Let's see what happens in Edo. And all eyes were on the judiciary. And shockingly, they, as some people expected, they didn't prove to Nigerians that the judiciary was up to the task in this matter. Because how can it be that the Supreme Court will give a ruling saying that presenting witnesses on a matter of non-compliance or on a matter of overvoting was not necessary, as long as there was documentary evidence, originals, or certified true copies from INEC? How is it then that the tribunal is going to tell you that, oh no, you must bring witnesses? So were they expecting us to bring 757 witnesses to court to testify when we had documents to show gotten from INEC? So
you said, were they expecting you to bring 757? Maybe not 757, maybe some. Did you bring any?
No, of course we did. And we brought witnesses to speak to our cases.
Yeah,
but again, it wasn't a matter of the number of witnesses. We could have brought no witnesses. We were not required to bring witnesses when the Electoral Act 137 expressly explains that in a case of non-compliance, for example, oral evidence is not required where there is documentary evidence to prove the case. That easily tells you that we don't need to hear from 200 people to show that there was non-compliance in 200 polling units.